Hi, in this video we're going to talk about powers of attorney. Particularly we're going to talk about what is a power of attorney and what are the formalities to make a valid Florida power of attorney. A power of attorney is very simple. It's a written document under which a principal appoints an agent to do things for the principal. So in other words, the principal, let's say, is me, and I want someone, let's say my wife, to do things for me in the event that I'm absent or I am incapacitated. So I tell in the written documents what my wife can do for me in the event I'm absent or incapacitated. So I enumerate the things that she can do, and then I sign that document in front of two witnesses. So that brings us to the formalities. How do you make a power of attorney valid in Florida? What are the formalities? Well, number one, the most important things is that you have to have capacity to make a power of attorney. You have to have the capacity to contract. So in other words, you need to understand what you're doing. You need to understand, like when someone puts a contract in front of you, you have to understand what the contract says and then sign it. And you have to have that capacity to make a power of attorney. Second, you have to sign the power of attorney in front of two witnesses, and your signature must be acknowledged by a notary public. The law doesn't say anything about who can be the witness, whether that witness can be a relative or a friend or whatever, but we recommend that the witness be disinterested party. In other words, people who don't have an interest in you. So we usually use our staff in our firm. So that makes it the power of attorney more valid. We have different things in Florida that we need to pay careful attention as to formalities. For example, the power of attorney is effective until you are incapacitated, unless you make that power of attorney a durable power of attorney. However, to make that power of attorney a durable power of attorney, you have to use certain words in the document. For example, this power of attorney continues to be effective even though I'm incapacitated. So you have to say those words in the document. More specific terms are in the Florida statutes. Another formality that Florida is very particular about is what we call in our practice the superpowers. The superpowers are important powers. So let's say you want to grant your agent the power to make gifts for you. So those are important powers. You have to initial those. Let's say you want to grant your agent the power to make a trust for you. Those are important powers. So the law wants you to initial before you grant that power to your agent. Let's say you want to change beneficiary designations in your accounts. You have to initial that too. Or you want to change or you want to create a right of survivorship in one of your deeds or accounts. You also need to make that power, you need to initial that power to make that effective. So Florida is very particular about what we call the superpowers. But in another video, we're going to be a little bit more specific about the superpowers. Again, more important, a Florida power of attorney needs to be signed by the principal, who is the person who is granting someone the power to do something, in front of two witnesses in a notary public. If you want to make that power of attorney continue to be effective even though you are incapacitated, you need to make that power of attorney durable. And to make that power of attorney durable, there gotta be a specific language in the power of attorney that says this power of attorney is durable and survives incapacity. Those are the main things. We're gonna continue covering more about powers of attorney in the next video. Thank you very much.